where it falls, because they have two obligations that sometimes seem in conflict. Number one, they have the interest of the client, but number two, if you read the rules of professional conduct, Rule 8 in the Tennessee Code, Rule 8, the rules of professional conduct, you come across a larger sense, and you have in view the idea that attorneys are to have consideration and defense of the law itself. So the defense of the client, the interest of the client, can go only so far. But at some point, it has to stop. And what has to come next is a defense of law and order, a defense of the rule of law. Now, we know that much of the abuse in our day is simply rejecting the rule of law. The rule of law is simply ignored over and over. Again, there's a great quote in Lou Rocco this morning from David Steele. He was the highest-ranking civilian in the Marine Corps intelligence and a former CIA clandestine services officer. And he says this. He says, most terrorists are false flag terrorists. Oh, I can't read the whole thing here. He said, in the United States, every single terrorist act, paraphrasing, has been a false flag or has been an informant pushed on by the FBI. In fact, we now have citizens taking out restraining orders against FBI informants that are trying to incite terrorism. We've become a lunatic asylum. This is something out of the national story. But we can see it here also. There is not an interest in the real rule of law. As he says, most terrorist events in this country are government-sponsored acts. They're trying to catch people as terrorists. They're trying to provoke people as terrorists. They feed them, they encourage them, they give them equipment, and the like. Very few genuine terrorist events have occurred in this country. And I would suggest that 9/11 is probably the biggest false flag of all. That is not something that is a naturally occurring terrorist act. Okay, that is a contrivance. It's probably a real estate deal in collusion with federal power, with some handy Muslim extremists from our great ally, Saudi Arabia. But Wade Hinton, I'm thinking about Wade Hinton's job here. Here he is. He has not said anything that I'm aware of, at least in public, based on attending one hearing and reading press accounts. He's not said anything about the danger to the city of entering into an illegal and constitutionally unwarranted act in banning the gig city. Right, the gig city is facing a ban with the ban on Airbnb and like networks. So Wade really has a duty now to say that, the client's interest I'm going to lay aside now, and I'm going to start saying things that matter about the law. The law represents the interest of the people, right? The Constitution protects their interest, and it's all statutes that give power and describe the limits on power. They are there to operate state government and, of course, the deep state. And they are there to create a public order, right? The rule of law. The attorney is, according to Rule 8, an officer of the legal system. Okay, so he's like a judge. Every attorney is effectively a judge, and can be called to be one. Right? He can be called to be a public defender, to serve the state that way for minimal pay. But he also can be called to sit in as judge, and that any attorney can be called to be a judge. In fact, all judges are attorneys. They're all attorneys. Called, they're elevated. A lawyer should further the public's understanding of and confidence in the rule of law, Rule 8 says, and the justice system, because legal institutions in a constitutional democracy depend, the rule says, on popular participation and support to maintain their authority. So here we have a question of Wade Hinton, the city attorney. Is he going to uphold the idea of the law? Why? Because authority depends on popular participation and support. If people continue if they continue seeing abuses of law, if they continue seeing false flags, you might say, in the local economy and free markets here by city and state actors, well, they're not going to support the authority anymore. The authority will have no authority. Right? Authority is the ability to get things done by others by force or the implication of having the power to use force. Okay, that's what authority is. That's what power is. Power doesn't mean you have to have one armed soldier for every citizen to maintain your authority, right? You can have a tiny army or a tiny police force or a tiny security service, and your power comes from the use of that, the discrete use of that power to bring a few into court and into jail or to the firing squad, and the others all live in fear of you. That's power. Okay, that's authority. And for the city and the state to have that authority, they have to have popular participation. We have to agree to it. Okay. Now, is the Airbnb ordinance proposed by Chip Henderson is a fix? It's kind of a workaround on an already unconstitutional system, which is called zoning. Is that going to work? Are we going to increase this participation? And is Wade Hinton, the city attorney, whose job is also as judge, right? Also as an officer of the legal system, are we going to hear from him at all? A warning about the unconstitutionality of this proposal. The rules say that that an attorney may have this conflict. In fact, this is highlighted in the rules themselves. The conflict must be resolved through the exercise, it says, of sensitive professional and moral judgment guided by the basic principles underlying the rules. And those principles include the lawyer's obligation zealously to protect and pursue the client's legitimate interests. Now, here's the kicker: within the bounds of the law, while maintaining a professional, courteous, and civil attitude. Now, Wade Hinton certainly has that, in a very polite gentleman, very professional man. But he pursues the city government's interest within the bounds of the law. The law is the statute. The law is the federal statute, but also it is the constitutional limits on that power. Okay, those are part of the law. And the law, in his perspective as an attorney, has to include the rulings from the Supreme Court. Now, I've been pointing out to you, my listener here at Nooga Radio, 1240 AM and 92.7 FM and 95.3 HD4 FM, right, on these multimedia platforms here, that the High Court has already discussed this issue, and it has discussed the $50 fine clause in the Constitution, which is the effective bullet in the knee, if you will, for the hobbling forward of the Chris Henderson ban on Airbnb. And that the $50 fine clause, well, it effectively puts the limit on. Let me see if I can find it here. I'm looking through Chattanooga versus Myers, 1990. Oh, I didn't mark it. But effectively, the $50 fine clause says that no crime, there's no penalty past $50. No fine or penalty past $50 by a city. Cities are corporations. They have civil authority only, and they have particular highly limited grants of statutory enforcement authority also. And that's another question, which really is kind of outside the purview of our discussions of the Airbnb disaster ahead. And that is the police department itself. What is its ground? What is its ground of authority? There is some derivative authority for the chief of police through the power of the sheriff. But again, that's for peacekeeping, which is really different from law enforcement. Peacekeeping and law enforcement are not the same. They are different functions, and yet we have the city enforcing statute repeatedly on many kinds of statute. With the agreement and complicity of the district attorney, going along with this, even though the Chattanooga versus Davis decision makes it clear there are many things that are wrong in the way things are being done now. And the judge, Barker, Mickey Barker, who lives up on Lookout Mountain now in retirement, or Signal, says that it's probably unconstitutional the way things are being done now. So there's unfinished business from 2001. Okay, that's 16 years ago. District attorney have been allowing certain things to take place that are in the direction of cities executing state law, and that's unfinished business. And but that's kind of beside where we want to go right now. We want to talk about this about the limits on the city. They are there, and I think Wade Hinton should avoid doing things that are, quote, prejudicial to the administration of justice. And that's what's happening. If Wade doesn't say, look, city council, we need to consider one thing, and that would be the following. Okay, in fact, that Wade Hinton, the attorney, sits in the middle of the council, shows that he is the real authority. He has the authority over the council members. Believe it or not, a member of the state judiciary has authority over the city council of Chattanooga. He has veto power. He can just simply say something about it being illegal, and then that's it. Okay, he can veto the whole thing say a veto. Okay, he can veto it because he sits in the middle. He can say, sir, ma'am, this bill is illegal. And that would be a proper thing for him to do. And that's what he needs to do. I know lawyers are there to protect their principles. Okay, they're there as agent to protect the principal. The principal says, I'm going to do this, just protect me. Okay, that's that, and I understand that. I understand that perfectly well. You should not be controlled by lawyers, period. On the other hand, Wade Hinton has a duty, especially in the way he is seated in the center of the city council, at the heart of the city council. He has a duty at this point to say, ladies and gentlemen, I have been doing my reading, and I want to bring you some bad news about your plan. And the bad news about your plan is that it's illegal. It is unconstitutional, and here's why. Okay, well, let's just start with number one here, the threat. Okay, the threat against the homeowner who does not comply with your scheme is this, and it says that. Hold on, it's on the last page before they all sign it. Okay, that's where this one part is. I printed it out on yellow paper, so I find it here in my stack. Yeah, the penalty section. Okay. Any violation of this article shall be punished by a fine of not less than $25 or more than $50. Okay? And that's because of the $50 fine clause. But notice how the city council plans to evade the clear rule in the $50 fine limit. Each day that the violation continues shall be a separate offense. Well, that's arbitrary and capricious. That is taking an offense and making something in the way of penalty power and threat and punishment that the city doesn't have. The city doesn't have that power because of Myers and Davis. Myers and Davis, two Supreme Court cases that show that fines are particular, and a fine cannot be a punishment. It simply can't be. And the only way there's any kind of jail for a fine is if you don't pay it. There is authority in the statute, when I looked this morning, to put people in jail if they have a fine that they're not paying. And that does not violate the ban in the Constitution in Tennessee, the ban on people being imprisoned for non-payment of debt. Okay, that's a separate exclusion favoring municipal corporations. So that's one thing. It's arbitrary, and here's why it's arbitrary and capricious. Remember what arbitrary and capricious means. It's an evasion, a willful or unreasonable action without consideration of or in disregard of fact or law. Well, the law here is that an offense is penalized or fined. It's a fine. It's not a penalty. It's a fine. Not more than $50. Now, the question of what a dollar is another question, but the background issue there is that the Constitution is referring to constitutional coin, right? 50 silver dollars, which if you bought dollar coins today, if each one's worth between, let's say, between $10 and $20 a piece, that would be about $2,000. Okay, so 2,000 paper dollars or 50 lawful dollars. But here no one pays any attention to that distinction. So let's just say it's 50 paper dollars, which of course is what you pay for dinner. I had relatives in town last week, and we went to a restaurant, and the bill for some hamburgers was $70. I just kind of frustrated me that eating out is that much money. So for one meal out with a couple of visitors from town, and one's old mother at the table, you spend $70. That's not much. And so if we don't accept constitutional definitions of money, then we have effectively the impotence of city government, to hassle anybody or punish anybody or to fine or threaten anybody in terms of dollars. And yet that's what the city council is doing in this ordinance. It's illegal, and it's arbitrary because who's to say that it's one day? Well, could it not be every hour the offense continues is a separate offense? Why not every 90 minutes? Why not every 2 days? Why not every week? Why not every year? You see, because you can't nail down which is just or which is fair, there's no underlying principle. It is arbitrary and capricious, period. That's it. And Wade Hinton, in regard to his duty, should be saying that. Okay, we are impotent to do anything. He let, at the meeting 2 weeks ago, at the city council meeting, he let the whole thing, he just let it slide. He said nothing about it. He just was going to let it go. Yeah, we'll just deal with it in court. But think about this. The city attorney should not allow something to happen that's going to infringe on someone's rights. And it's going to be a grave burden to the homeowner who says no. There's going to be a homeowner out there who says, you know, I'm not taking it anymore, and I'm going to say no. I'm going to say make me. And then his lawyer bill the toll on the time with that lawyer's clock starts ticking, and then thousands and thousands of dollars are going to have to be spent by this man to defend his property rights. That is a grievous burden to anybody to have to engage in legal help, have legal help to maintain your rights. Well, there are other things that are violating the arbitrary and capricious standard, and the main thing is the map. This is point 2. I don't know if I can get to point 3, but point two is the map itself. You can find this map at Nooganomics.com. Our chief sponsor, that's Nooganomics.com. Just do a find on Airbnb, AIRBNB, and read my analyses there. That's Nooganomics.com. Our chief sponsor of the website, The Man Who Matters here, sponsor of the David Tulis program. The main offense in the way of arbitrary and capricious is the map. And this is a procedural offense because it violates God-given, constitutionally protected rights, right? Your rights come from God. They're not constitutional rights because that implies that the right comes from the Constitution. No, it comes from God. And because you're made in God's image, you have those rights. You have them, and they belong to you, and you just have to know that, okay? But they're guaranteed. They're protected. They're protected by the Constitution. And so we're not constitutionalists, okay? We don't worship the Constitution. We worship God. And we rely on the promises that our forebears made with the government to defend us today, even though there are rampant abuses at many, many points. Rampant because we have commercial government and not constitutional government. We have states. We have a state today, which is at war with the people. It is at war with the people, though they don't recognize it. People don't recognize it. And the Chip Henderson map is arbitrary and capricious. Think about it. You live on Jones Road, let's just say, in a very nice house. You've got some trees in the front. You've got a nice little driveway passing your garden, and then you make a slight left turn and pull into your little parking garage there. You have a porch, and you have a little bit of forest in the back. You have a bird bath in the front. Now, on the right-of-way, on the other side of the ditch that's hard, a little kind of a bear to mow, is a street, okay? Across that street, there's another house. That's my house, okay? That's my house. My house is a little bit less well-kept than yours. If you look at my house today on the top of the hill, on a dead-end street, you'll see that it needs a bit of care, right? My bushes are pretty shabby, and I've got some rotting wood in the front that kind of made a little rising up area of bushes and flowers and things along the edge of the river stone that is the front, the facade of that building. A house that had been added onto a couple times. I do mow, and my bird bath is pretty shabby too. It's concrete. It's probably 30 years old, and it's falling apart, and it leaks. And so the water level in the bird bath is never quite as high as it should be. All right. We're in the city, Jones Road, right? Now, I'm in the map. I'm David Tulis. I can have an Airbnb house. But you my listener, you're on the other side of the map. You can't do Airbnb. You can't even apply for a rezoning to get permission to be a commercial operation. It's denied you in the change. So I can have renters in my house. I can generate cash flow. I can be part of the gig economy, the gig city, right? The fabled Chattanooga with its high-speed internet. The future Beijing of Tennessee that is going to raise the wall and ban Airbnb. I can do it, and you can't. Think about that. That is arbitrary and capricious. The very fact that a map exists is arbitrary and capricious because I can do Airbnb if I pay the fine, right? If I pay the fee. If I beg permission from government to do that. I'm sorry. You and your children just have to live in that house, and that's it. You can't do anything. You can't rent it. And if you rent it anywhere, if you're on any platform, there may be 100. We will find you out. Donna Williams down at the Economic Development Office with Mayor Andy Burke. She is going to sniff you out. She's got time to stamp a screen grab that shows that you, my listener, are illegal and unlawfully and arbitrarily and capriciously renting out your house to people, making money. You're making money, taking part in a $5 billion industry, and you are a crook. And we're going to stop you. We're going to bring enforcement action against you today. David Tulis.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240.